number 1 CRL 71 of 2009.
The appeal is dismissed.
For judgment item number 2 CRL 193 of 2011.
The appeal is this letter which was sent way back to the court on 9th October 2020. Sorry, 9th October 2001 has not been listed even once. The court does not propose to entertain the letter at this stage. Petition is disposed.
Item number 4.
May I please, Your Lordship? This is regarding fixation of the headquarter of a Gram Panchayat. Your Lordship may kindly have a glance to page 11. There is an, as per the provision of the statute, that is Orissa Gram Panchayat Act, Section 3, Section 4 and Section 149, the state government on 20th October 2001 issued a notification under Annexure 1 that at page 13, serial number 58, a Kirimeti Gram Panchayat is constituted with 12 villages, revenue villages. The name has been mentioned at page 13. And the headquarter of the said Gram Panchayat was fixed at village Kirimeti. 2 persons filed application before this honorable court. They made a representation to the government. They filed a writ application, and this honorable court directed the state government to consider their representation. Under Annexure 9, your Lordship will found the deputy registrar considered as if it is a direction issued by this honorable court to change the headquarter of the Gram Panchayat from Kirimeti to an Kenduguda, which is not even a revenue village under these 12 villages. Your Lordship, at page 23, Annexure 9, in pursuance of the order of the Honorable High Court of Orissa in WPC number so and so regarding fixation of the headquarter of Kirimeti Gram, and after careful consideration of the representation submitted by Srimati Tarajani, Sarpanch Kirimeti Gram Panchayat, and the Gram Panchayat resolution, government has been pleased to order that Kenduguda is the biggest hamlet of Kirimeti revenue village, having largest number of population, and considering its location and population and administration of convenience supported by the Panchayat resolution, headquarter of Kirimeti Gram Panchayat shall be located at Kenduguda, hamlet of the said Kirimeti revenue village. This is contrary to law. Your Lordship may kindly have a glance to the counter affidavit filed by the state. I will take to your Lordship to.
It's been Kenduguda for how many years now?
No, that has been stayed by this honorable court.
When was it
status quo order is there. Your Lordship, the first order, the order dated 3/2/2003.
1 minute.
Status quo as on date in respect of construction of Kirimeti Gram Panchayat office building shall be maintained.
Oh, And it is,
Until-
that stay is continued.
State is
All
continued.
right,
till-
if you now wish to change the headquarters, you give a notice, public notice and follow the law. This status quo is continued for 19 years now.
For
Ah.
last 20.
You see, if by virtue of an interim order passed with this on 2nd January.
3/2/2003.
21st January 2003.
So sorry. Yes.
Ah.
sir.
The headquarters of the Kirimiti Gram Panchayat has remained at Kirimiti and has not been shifted as was proposed, and has not been shifted to Kenduguda as was proposed by the impugned notification. Resolution, sorry. As per the impugned order dated 8 November 2002. Full stop. It's for almost 2 decades. The status quo has continued. There has been no attempt by any party to have that vacated. Paragraph in that view of the matter, while making the stay absolute, the court directs that in future, if there is any move to shift the headquarters, it should be done strictly in accordance with law, with due prior notice to all involved. The petition is disposed of in the above terms.
At present, the headquarters shall be remain at Kirimiti.
That status quo,
Yes,
your lordship has-
otherwise they may be misinterpreted that.
No, your lordship has directed to maintain status quo.
Yes.
That is okay.
Item number 5.
Obliged.
Five lordship, no instruction.
No instructions dismissed.
Item number 6.
Item 6, Miller, on behalf of Mr. Patnaik, may be taken up next week because he's ill, Miller, on the.
Tell us what the matter is about.
Because, I'm not aware of the matter because
No,
Miller, on the.
Don't please come all the way just to take an adjournment. At least
I-
be familiar with what the matter is.
I've only taken consent from other side, no? That's why I'm praying.
See, you cannot take us for granted like this.
Yes.
You're not like some courier boy. Somebody gives you a paper book saying, go take an adjournment, you go and take an adjournment. Be familiar with what the matter is. What is the matter about? We pass it over, try and examine what the matter is about.
The matter is that it is industrial tribunal award that was challenged.
Hmm.
And
Is
that
a
was-
writ appeal maintainable at all?
that lordship asked last time.
How is it maintainable, sir? We're not simply adjourning like this. You examine maintainability, we'll pass it over.
Yes, sir.
Come back.
Yes, sir.
Yes.
Item number 7.
Item 7 Miller has become infraction.
Infractuous dismissed.
Item number 8.
The noting that I have not complied with the lordship's order, that has been complied. I filed yesterday I have filed, that is why it is not attached. That I have deposited already 16 lakhs 32,000.
Pursuant to the order passed with this court. On 26 September 2002, the appellant state would have deposited the sum of 16 lakh 32,000 in this court. The said amount now be placed in a fixed deposit with the Nationalized Bank, initially for a period of 6 months to be kept renewed during the pendency of the present writ appeal. Is a notice returnable December 14. Notice additionally be served through speed post. Tracking report be placed in record.
Item number 9.
May I please, Your Honor? There's a delay of 94 days in filing the
What is the matter about, sir?
matter is that Honorable Single Judge had passed an order basing on doctrine of non-traverse. Even though the writ application was filed, a counter was not filed. On that basis, the judgment was passed. The grounds taken in the writ appeal is whether employment can be given to a married daughter under the policy. That is the ground. Government has given a clarification if Lordship sees annexure 4 at page 15 of the writ appeal.
Have you complied with the impugned order?
No, man.
Why not?
Because on the ground that if a lordship may see for a moment page 15 of the writ appeal.
No, you have yourself decided. There is no stay
No, no,
granted
no.
by this court. There is no stay granted by this court. So how come you have not implemented? They have not filed a contempt also.
No, my lords.
So it's not hurting you, sir. Why waste the time?
No,
Why waste the time of the court? They are not asking for implementation. You have decided not to implement. Why two judges should break their heads on all this? They simply say that nobody's interested in the matter. The single judge is granted employment and the person is not coming forth to get employed. Obviously, he's not interested. If he files a contempt, we'll ask you, we'll revive the appeals. It appears that in the last 7 years during the pendency, nearly 8 years after the disposal of the writ petition in favor of the respondent by the learned single judge on 26 November 2014, the respondent has not come forth for implementation of that order. No contempt application also seems to be filed. On its part, the appellant has, even without a stay being granted by this court, does implement the impugned order. Full stop. In other words, all around, there seems to be a complete indifference as regards implementation of the order of the learned single judge. In the circumstances, the court sees, full stop. Even today, the present appeal was listed in its own turn without anyone mentioning it for early listing. In the circumstances, the court sees no reason why it should entertain the present appeal. It is disposed of as and when the respondent comes forth seeking implementation of the impugned order of the single judge. It will be open to the appellant to revive the present appeal.
Item 10.
For the respondent. I am for the respondent.
None appeals for the appellant, dismissed, non-prosecution.
Item number 11.
No instruction.
No instructions, dismissed.
Item number 12.
None appeals, dismissed.
Item number 13.
Lordship, we are challenging the order dated 3/10/2016, passed in WPC number 16292 of 2016, Your Lordship. In this particular writ petition, there was in 1/7/2015, the government brought a notification for bifurcation and reorganization of the Gram Panchayat. Accordingly, the Gram Panchayat was reorganized and village Hingupali was considered to be the headquarters. But then there was a dispute between.
Yesterday, my lord, that
Yes, similar matter, my lords have
same impugned order, my lord.
Against the very same impugned order of the learned single judge, writ appeal number
Writ appeal number
508
of 2016.
508 of 2016.
501.
501 of 2016 has already been dismissed by this court by an order dated yesterday's date, 17th October 2022. Accordingly, the present writ appeal is also dismissed.
Item number 14.
I am permitted to better application. Some development is going on there. That's why
The writ appeal, sir.
Yes,
No
ma'am.
question of better. You say counsel for the appellant seeks leave to withdraw the present appeal, dismisses withdraw. Right.
Item number 15.
Lord, in this appeal, there is a delay of 292 days and the single judge held that 311 days. That is, the respondent underwent imprisonment for violation of security rule. And that was those 311 days to be counted so as to eligible for 9 years and 9 months period so as to be eligible to get the pension. That is the only question involved in this.
Is 290?
355.
355.
292 days.
So our calculation is slightly different. So it's 355. There's an inordinate delay of 355 days in filing the appeal, which is not properly explained. Accordingly, the MC number 60 of 2017 is dismissed. Consequently, the appeal is dismissed.
Item 16.
Lordship, I am appearing for the appellant in this case. Lordship, the writ appeal is directed against the order dated 21/11/2006, passed by the Honorable Single Judge in the writ petition number 6542 of 2008, and the writ petition was dismissed, and the disengagement order of the appellant was upheld, and the appointment of the private respondent was also upheld, my lord. The Lordship may kindly see
Come to para 10, sir.
my lord, your Lordship, I may kindly see the order dated 4/1/2017 passed in this writ appeal. And I may be allowed to place the fact, my lord.
You continued as Gram Rozgar Sevak now.
Miller.
All right.
And I was duly appointed, and later on I was disengaged.
It has been served.
Miller. And the respondent number 4 was appointed, and I am still continuing, my lord. And your Lordship, the
Yeah. 2/1/2017, somebody appeared in fact. Carry on, sir.
The Lordship may kindly see page 38.
Carry on.
The Lordship, page 38
Yes.
is the advertisement, my lord.
All right.
And here it is stated that incomplete application is liable to be rejected. And the application of the respondent number 4 was not in order, and it was rejected, my lord. And thereafter, the collector reopened the case, stating that the respondent number 4 score higher mark than you, and therefore I was disengaged, my lord. And my submission before your Lordship is that the case should not have been reopened, because it would reopen the floodgate for other candidate, and moreover it is not permissible also legally, because his application was not in order, and that's why it was rejected summarily, my lord. And he filled up the application form in a highly cavalier and irresponsible manner, my lord. He didn't fill requisite column, etc.
What is the big defect, sir?
Your Lordship may kindly say.
What is the big defect? Come to para 10 of the impugned order. Please come to para 10 of the impugned order.
My lord, I'm coming.
Kindly read, sir.
May I read it?
Kindly read, sir.
My lord. In course of hearing, Mr. Patnaik, Law Counsel for the opposite parties 1 and 2, has produced the record relating to selection of GRS under Sarfans, Sunbows and GP. On scrutiny of the same, it reveals that the petitioner, opposite party number 4, and others apply for the post of GRS in the education biodata. The column mean for marks secure, the opposite party number 4 has mentioned the mark of HSC as well as +2 arts in the column total marks. The same is not a ground to reject the application for the opposite party number 4. Moreover, the opposite party number 4 annex all mark sheet. If there is any variant, the employer can verify the same from the mark sheet attached to the application form. On a school, the opposite party number 2 found that the opposite party number 2 has secured more marks than the petitioner in plus 2 examination. The petitioner has secured 433. The opposite party number 4 has secured 449 marks, which is much more than the petitioner. In view of the same, the collector rightly disengaged the petitioner from the post of GRS, my lord.
Such a flimsy ground to reject his candidature.
Your lordship, he did not fill in the particulars. Moreover,
He's not suppressed anything. He has in fact secured so much marks. He's attached all the mark sheets.
Your lordship, see the application form.
It's such a flimsy ground to reject.
Page 66. Page 66, page 65, my lord. Here, he has not stated the marks secure, my lord. Total,
Sir, he
only
attached-
total marks, only total marks.
Oh, what is this? He's
And,
not suppressing any facts, sir.
And he has taken the plea that he is a graduate, my lord. And in similar circumstances, they have rejected not less the candidature of 3 candidates. The same
He has
column.
scored more marks than you. He has attached the mark sheets, merely not filling up one column. How does it make a difference? He's not suppressing any fact. He's not misstating any fact. Nothing.
But it is against the term and condition of appointment.
This is not that, sir. This is not that kind of a thing.
And your lordship may kindly say they have rejected the application, the candidature of 3 candidates on similar ground. They file a counter. Later on, he submitted the relevant mark sheet. Your lordship may kindly see the counter page 7. Counter by respondent number 1 and 2.
Give us the para number.
Your lordship, I'm coming to that. Your lordship, 1 Rahasa Barik. His application was rejected on the ground that application form not signed. And
that is very different, sir.
And one Guru Prasad, one Jaskechan Behera, and his application was incomplete.
That's different. We don't know what is incomplete. We do not know what is incomplete there.
And his application was incomplete because he has not he did not fill in the material particulars, my lord. And later on he submitted. Later on. And
nobody says later on. Nobody says later on.
And he submitted.
So don't simply say later on. Where do you get it that was submitted later on?
He submitted a repentation enclosing all these things. His repentation Your Lordship, the copy of his representation is at page 93 of this writ appeal. Page 92 and page 93. Here he has stated,
No, again he says.
he has stated in this connection, I have attached here with my mark sheet of Council of Higher Education, Odisha, page 92, my lord. Odisha BBA, sir, for your kind information and verification.
Don't stop there. The crucial word you don't read.
And I would,
Please read that crucial word which you left out.
in this connection, I have attached here with my mark sheet of Council of Higher Education, Odisha, Bhubaneswar, for your kind information and verification again. Again, I would therefore request
Mr.
you.
Counsel, don't argue like this. When two judges are reading a document, asking you a question, don't pretend that we have not read that word and we are not asking you a question.
My lord.
What does the word again mean?
Again means.
What does again mean?
Again mean that that it means that he submitted.
And what was your argument?
According to him.
What was your argument? That he never submitted these documents earlier.
But he has.
And I asked you, where do you get that? You are referring to this representation. At least we remember the questions we asked. You may forget it.
Miller.
Don't make submissions contrary to the record, sir.
And your lordship, page 66. Here the region assigned is document wanting. Page 66.
That is why he has gone to the court, sir, because this is incorrect. No document is found wanting. He simply forgot to fill one column, that's all. This is not a case of suppression of fact, nothing.
And in similar cases, they have rejected the candidate.
It is not similar cases. Those cases which you read out are not similar cases to this.
Incomplete application.
That's right. That's very different from saying one column has been left out.
And your lordship, I rely on some.
Yes, please.
Your lordship, it is by Delhi High Court, Jatasankar Shukla versus UPSC and others.
Give us a copy of the judgment.
Miller. I got the same letter.
One copy. No, only one copy each. All right. Yes. Sir, yeah, Orissa High Court judges are not very fortunate. Other judges are very fortunate. Orissa High Court judges, we sit in a DB, you have to share one copy. All counsel, not only you, sir. Not only you, all counsel think two judges can share one copy. Enough. Other high courts, they believe that each judge should get a copy.
Your lordship, I apologize.
It's our misfortune, sir. Only Orissa High Court has this treatment.
Only yesterday night, I could not Your Lordship, in
Jata
Jata
Shankar Shukla, the head note says whether candidate can change the information furnished in the application at a subsequent stage. It is
That
not a
it-
question. No, he's
and
not
it was-
changing any information, sir.
it was held that instruction clearly so that a candidate cannot change the entry made in the application. form at
Where is
any
he changing
subsequent
entry?
stage.
Here, he has not changed any entry.
And Your Lordship,
He did not indicate his educational qualification. That's not the. Failure to enclose essential documents. That's correct. All this is rightly held, sir. This is not the similar case on hand. We don't have a similar case on hand.
and Your Lordship, in Your Lordship, one Kerala High Court, Nina versus Kerala Public Service. DI. And one by Ajit Pratap Singh, my lord. Here it was held at
Can we have a benefit of the judgment, sir?
given, sir. Data Sangha Shukla. The fact patterns are might not be same, but the ratio is that in subsequent stages, no alteration is permissible, my lord.
It's not an alteration, sir. He has not altered his application form at all.
Content of the advertisement, I have already.
Want of signature in beyond time. All right. Anything else, sir?
Miller, my submission is that he fill up the application form in a highly cavalier manner, and it was liable for rejection summarily. And moreover, my lord, quite belatedly, he also asked for rechecking, etc. And in similar circumstances, they have rejected the application of 3%.
All right. The present appeal is directed against an order dated 21st November 2016, passed by the single judge, allowing writ petition civil 6542 of 2008, filed by opposite party number 4. Dismissing the writ petition filed by the present appellant and upholding the order passed on 25th April 2008 by the Prosecutor District Rural Agency Bargarh (DRDA) respondent 2 disengaging the appellant from the post of Gram Rozgar Sevak (GRS). Paragraph. The background facts are that pursuant to an advertisement issued on 13th August 2007, for filling up posts of GRS in 248 Gram Panchayats (GP) of Bargarh district. Appellant and respondent 4 were among the several who applied for the post. The appellant was selected and empaneled as GRS of the GP under the Bijepur block. Thereafter, the Sarpanch Sanbhausan GP issued a letter on 14th November 2007 appointing the appellant as GRS in Sanbhausan GP. Paragraph. As far as respondent 4 here is concerned, being agreed as non-selection for the post, he filed an application before the respondent 2 on 19th November 2007 for rechecking of the mark sheets submitted by the candidates, including that of respondent 4. When no action was taken, he submitted an application before the collector and district magistrate Bargarh on 26th February 2008. And followed it up with another representative March 2008. Paragraph. It was pointed out by respondent 4 that he had scored 449 marks out of 900 higher secondary examination of 2003, whereas the present appellant had scored only 433 marks. Full stop. Pursuant to the above representations, a notice was issued to the present appellant on 31st March 2008, asking him to explain why he should not be disengaged from the post of GRS. Full stop. After his reply was examined on 25th April 2008, respondent 2 sent a letter to the Sarpanch pointing out that as a result of respondent 4 applying and reappearing in compartment in the English paper in the +2 examination, after recalculation, he secured 449 marks, which was the highest, and therefore he was eligible to be appointed as GRS. Full stop. As a result, the appellant was disengaged by an order dated 8th May 2008, and respondent 4 was engaged in his place. Full stop. Before the learned single judge, the plea taken by the appellant was that in the application form submitted by the respondent before, in the educational biodata, in the column meant for single quotes marks secured, respondent before had mentioned the total marks obtained both in the as well as the +2 arts. And left the column pertaining to which page is that application form?
It is 65, my lord. 65.
And left the column indicating single quotes marks secured,
And he is also
both in the
wrongly
HSC
mentioned.
and +2 arts blank. Full stop. On this basis, it was contended by the present appellant that respondent before had submitted an incomplete application form. Full stop. This plea was rejected by the learned single judge, who observed that respondent before had in fact enclosed all his mark sheets, and it could not have been difficult to verify therefrom as distinguished from the total marks. Full stop. The mere omission to mention the marks secured in the relevant column while enclosing the mark sheets ought not to be a ground to reject the candidature of respondent before, who in fact secured 449 marks, whereas the appellant had secured only 433 marks. Therefore, the order disengaging the appellant was upheld. Paragraph. Learned counsel for the appellant relied on the decision of the High Court of Delhi, dated 17 July 2002, in writ petition number 21129 of 2002, bracket Ajit Pratap Singh versus Union of India. In that case, the petitioner's candidature for civil services bracket preliminary examination was rejected had he had not indicated his educational qualification in the application form. This was an essential information and distinct from not filling up the column pertaining to single quotes marks secured, even while mentioning open quotations, total marks unquote, and enclosing the mark sheet, as has happened in the present case. Consequently, the court is of the view, this court is of the view that the decision in Ajit Pratap Singh is distinguishable with facts. Reliance is next placed on again the decision dated 13th January 2010 of the Delhi High Court. In writ petition civil 13451 of 2009, bracket Dr. Vidran versus UPSC. There, the candidature was rejected because the candidate failed to enclose the essential documents like certification of qualification, reservation to the application for the post. Full stop. In the present case, there is no failure by respondent before to enclose any document. Consequently, this decision is also not of any assistance to the appellant. Paragraph. Reliance is next placed on the decision of the Delhi High Court, dated 17 July 2002, in writ petition civil 20916 of 2000, Jata Shankar Shukla versus UPSC. There, the question posed was whether a candidate can change the information furnished in the application form at a subsequent stage. Full stop. Here, respondent before has not attempted to change the information. provided by him in the application form. Paragraph lastly, reliance is placed on a decision dated 22nd September 2008 in civil appeal number 5766 of 2008, bracket T. Jayakumar versus A. Gopu, where the Supreme Court noted that an earlier application form did not even have a signature of the candidate and was submitted beyond the time, whereas the second form was submitted beyond the time. These facts, the facts of the present case are totally different, and therefore the said decision is also of no assistance to the appellant. Paragraph. The court is of the view that the learned single judge was justified in observing that the mere non-mention of single quotes marks secured in the relevant column, even while enclosing the complete mark sheets, was not a valid ground to reject. Was not a valid ground to reject the candidature of respondent before, who admittedly secured more marks than the appellant. Consequently, the disengagement of the appellant, when the above facts came to light, was wholly justified. There's no merit in the present appeal and it is dismissed as such. The interim order is vacated.
Item number 17. The OP number 4 may be continued to Malad in that post. Was selected.
What are you saying, sir?
The OP number 4 Malad was continuing earlier. Now he's Malad.
The lordship,
The appellant is continuing that post.
the appellant is continuing. All along he is continuing. And he could not be disengaged because a stay order was made by the Honorable Court.
Now the stay order is vacated now, yes. Memo is taken on record, dismissed for no instructions. Dismissed.
Item number 18.
Maybe gone to the side, my lord, regarding Puri temple. Puri temple, my lord, lot of works are there, but the most important verse is Natamundap. After the Jagmohan, Natamundap, where they were pouring the money, that Natamundap beam has been cracked from 2018, my lord. At that time, I told this needs to be repaired immediately. They took 4 years for examining. They told not required. They installed the instrument to monitor the development of the crack, whether the load is, whether the shear strength and others there. Now, the day on which after my lord's order, they got up from the slumber. I told that to give the report of IIT. Last 4 years they are making the report study. What is the report? I have seen that report has been produced me on that same day. It is mentioned that the beams which has been cracked now working as a cantilever. It has been totally cracked. It is working as a cantilever. That means does not take any load of the roof. That means what I have told in 2018, this seems to be correct. Then they want to advise, let us do further testing. I don't not necessary now. Don't go further testing. It has already told that the beams has been working as a cantilever. So it needs to be repaired. So he has promised, the SA has promised, I will repair it and within 4 months we'll complete it. Next comes Jagmohan, which we have done last 2017. Outside, there is a lot of repairs there, and there is a lot of others there. They are just started attending that work. They have also told that these 2 works will be completed by within March of this 2023. This they have told, they have given an affidavit, they have given, assured this Honorable Court on 23rd, 2019. These 2 works will be completed in 4 months. But today, things are as it is. By my order, my court's intervention, they are now got off. They have promised me that they will complete within March 2013. I told that these 2 works should be completed, then we'll go to the further work.
Actually,
This is most important work.
lot of correctional measures are being undertaken. I think my learned senior friend has gone to this spot and collected certain informations. So this is the stage, and in joint venture of ASI and the state administration, we are moving forward to the developmental works.
State government has got nothing to do in these 2 works because the only
Where is your affidavit, sir?
I have given the report. I have given application.
69. You have seen Mr. Marti?
I have given
Our affidavit.
No. His affidavit.
His affidavit, yes.
I have given mail. I have submitted in the court. On 10th, after the orders of 8 days before, I have submitted on the 10th of this month.
The amicus curiae has submitted a report of his visit to the temple. You visited only the Konarak?
No, first is Puri temple.
Both the place they have been.
Both the status report I have submitted.
All right. What about Konarak? What is the position there, sir?
About Konark?
Yes.
My lord, I have nothing to say. In Konark, there is a lot of debate in this court. In Konark, they say there is most particular things. One thing is most important, that this Konark, the Jagmon, is filled up with the sand in 1903, my lord. That sand is to be removed or sand to be kept. I have suggested that the sand to be removed because I have gone to Rome. I have gone to talk to the ICMR people. They have also given report that sand to be removed. So the court has ordered that make a national seminar, make a debate, then come to the conclusion. Accordingly, there was a seminar in Konark on 28th and 29th, 2020. It has consciously decided that sand to be removed. Now they have said after, because my lords have ordered that I will visit. Before I visit, 3 days before, they have started doing this scaffolding and others and trying to locate the hole where they have to go enter, because the thickness of the wall is about 16 to 18 feet. So that is a very, very technical matter. But unfortunately, I told them, I have discussed with the SI authorities, I have suggested there must be a technical committee in this spot to locate it. There cannot be casual, otherwise it will collapse. If necessary, I have also suggested, if the technical person is not available, bring from the ICMR, where they are expert in Rome. They have suggested the sand has to be evacuated. That has not been done. In 2010, ICMR people have come 3 times to visit the spot. Mr. Pilden and Mr. Corsi, nothing has been done, my lord. Now they have started the work. They are telling that we are started, but I request my honorable lord that let the court monitor, at least let the work be done. Otherwise, they are not taking that seriously.
All right.
As they have done in Puri also.
All right.
So my personal request to the honorable court, that monitor at least once in 2 months or once in a month, as per the convenient, so that they will come up and do the work, my lord.
All right. He says submitted a report dated 10th October 2022 after visiting the Temple of Lord Jagannath at Puri. He has highlighted the work to repair and restore the beam inside the Nata Mandapa, as well single quotes, distress on outside Pidha layers of Jagamohana, unquote. The report states that the work is being, the above works are being undertaken by the Archaeological Survey of India, ASI, and is expected to be completed, according to him, by 31st March 2023. Paragraph. As regards the Konarak monument, he states the work of removing removal of sand from the Jagamohan, is it?
From Jagman, yes.
Has already started. So you put down both the writ petitions. Huh? This first one, second one, together you put. Has already commenced. He requests the matters to be kept on board for the court to monitor the progress of the above works. This is on 5th January. Thank you, sir.
May I please, Your Lordship? Well, I am applying for the petitioner copy of the affidavit may be sought from me.
Report, it's a report, sir. You can obtain it from the court master. Just bring your pen drive and you'll get a copy.
Okay.
There are two other.
My lord, may I submit one thing, my lord? This whatever report is submitted by the amicus curiae and whatever submission made before my lord, it must be correlated with the ASI authority. So better to whatever report they submitted for my lord and what observation made thereon.
You just send a pen drive, sir. You will get it all. Just get soft copy of everything. You can send it to them, maybe emails. Very convenient it is, sir, nowadays. So just give a pen drive, you'll get a copy of the entire paper.
Have the copy to
No, we have received the copy. What I am submitting, the ASI authority must be consulted with the court and they should proceed because whatever submission they made and the work will be done accordingly. It may be prejudiced in any manner. That's why I am saying, my lord, that proper instruction. If anything will happen, this is not proper. That's why
you can send it to your client. You are appearing for ASI, no, sir?
Yes. So,
so
I have to take the instruction. Suppose some report has submitted to the court and copy is given to me. I will provide to them. They will come with a proper plan and proposal. Then it will proper to agreement. I think so.
You say it will be open to counsel to obtain from the registry on a pen drive soft copies of the entire paper book, including the reports submitted by the amicus curiae. All right.
There is a connected writ petition 9792 of 2018. Prayer is towards CBI inquiry. That may be dismissed because these are
no, my lord. In that matter,
that is
where is that?
No, it is tagged with this matter. That is the prayer.
No need for that, sir.
Yes, my lord.
No need for all that CBI and also.
No, my
for
lord.
CBI investigation.
It is related to the Ratnabandar matter, my lord. Till yet, my lord, the amicus curiae is not allowed to visit enter into the Ratnabandar and submit his report about the wall and ceiling of.
Amicus is doing the work phase by phase. So far as CBI investigation is concerned, this is not at all required. I think.
I am sorry, my lord. I am for temple administration, lord. Here, loss of key of Ratnabandar is seeking for. I think
that is also subject matter
loss of
judicial inquiry.
Subject matter and also this is a matter where the state government appointed my lord Justice Raghuveer Das appointment commissioner inquiry and my lord Justice the commissioner inquiry also given a report to the state government. It has to yet to be notified, my lord. So in view of that, my lord, the prayer they is seeking for, so I think it is not regarding loss of key in the Ratnabandar.
In these petitions, the petitioner also prays to count the valuable things of Lord Jagannath to be counted again, which is counted before 2 decades. In 80s, it is counted till after that it is not open, it is not counted, it is in well condition, it is there or not. The state government let file the affidavit. That
I think these are not the things to be interfered by the judicial forum.
But where is you filed a reply, is it?
That 9792.
Have you filed any reply?
No, reply I have not filed. Okay. But the main prayer is for CBI investigation.
No,
but that is a judicial inquiry going on.
There are 2 prayers.
No, four
Really completed.
Judicial inquiry is Honorable Justice R.B. Das has already submitted his report. So again, this so far as the first prayer is concerned, that may be
fourth prayer.
Oh, that so the so-cause may be confined to fourth prayer only. Other prayers may be dismissed.
All right. You see, there are 4 prayers in the presented petition. The court is, however, willing to examine only one of them, which is prayer number 4, about taking stock of the properties and valuables inside the Ratnabandar of the Lord Jagannath Temple at Puri. Stop. before issuing any further any directions in that regard, the court would like the state government, the
No, my lord, the
temple administration,
temple administration will give
to
the-
file an affidavit in that regard. The affidavit be filed within 4 weeks with copies to counsel for the parties, all the other parties,
My lord,
including the
prayer-
petitioner.
Prayer number 1 to 3 is dismissed.
Yes, yes.
Lordship may kindly
It is
clarify.
clarified that the present petition is confined to prayer number 4, as mentioned, and the other prayers are rejected.
Obliged, my lord.
Along with me, Chandrakanta Pradhan name may be reflected.
All right, all right. 5th January, right.
Supplementary list item 19. Item number 19.
None of is dismissed.
Supplementary list item 20.
Your lordship may kindly permit to withdraw this matter.
All right. Counsel the petitioner seeks leave to withdraw the present petition. Is withdrawn.
Supplementary list item 21.
Item 21, the conducting counsel, Mr. Karunakar Jana, is severely ill. He is suffering from fever.
That is regarding all appointments in consumer. That is going on. Your lordship is aware of the.
It's a counsel for the petitioner stated to be unwell. 12th January 2023.
Item 22.
Item 22, my lord, the prayer is regarding the challenging the inaction of the opposite party number 1 BPCL in not restoring the facility of HST at the dealership station of the present petitioner, which is causing inconvenience to the general public. The facts constituting this petition is that, my lord, the dealership of the present petitioner in the name and style of Janata Service Station was granted.
Your dealership is continuing?
Yes, lordship.
How is it a PIL, sir?
It is not PIL, it is
Then
application
why
by
is it
the
listed before this bench?
present dealer.
Why is it listed before this bench?
Similar matter was disposed of by Honorable Court in WPC number 229 of 2016, where we have stated that the dealership is still there and allotted to the present petitioner.
That is regarding recommissioning of the dealership, reconstitution
List
of
before the
the
roster
dealership.
bench of the learned single judge
Different matter.
on 6th December.
Item 23.
No, item 23, my lord, Mr. Mahapatra is suffering from cancer, my lord, and is unable to speak, my lord. He is appointed, he is engaged Mr. S.K. Stodding, my lord, senior advocate, my lord, today. I am appearing on memo I am filing, my lord.
So we'll pass it over.
No, no, I take up any other day, my lord.
Why? Mr. Sarang is not available.
He is not available.
Why?
He has not taken the, today he has given, my lord, the memo.
I think the order has already been complied with.
Let's see that.
Because your lordship may kindly see page 2 of the internal page 2 of the impugned order.
Yes.
There are certain time-bound directions. The learned collector is directed to conduct a lottery through a committee of which the collector himself shall be the chairman. The entire proceeding of the lottery shall be captured within video recording. All the genuine applicants who had applied in 2012 for allotment of shop rooms in 2013.
They're all over, sir.
All since long.
You
This
see,
is
the
a
subject
matter of-
matter, the present, the writ petition, in which the impugned judgment dated 13 January 2017 has been passed.
My lordship may
Has
take
all
up,
been-
next week, my lord, your lordship
is all time bound, and the steps taken, steps that directed to be taken should have been taken long ago.
And there is no
So
stay
there
order
is
in
no
the
stay of the impugned order of the learned single judge in the present writ appeal, which is in which there has been no effective hearing for over 5 years now. In the circumstances, the matter does not call for any interference. The writ appeal is dismissed. Just put down that appearance.
Item 24.
You've given your memo, right?
Yes.
My lord, I have given the memo. My
Right.
lordship may taken
There is nothing in this, sir. Nothing.
I have to clarify it, my lord, because I don't know what is the matter, my lord, because
It's not our problem, sir. Yes.
It is 24.
Yes.
Sir, my lord, I have taken the instruction that there is a.
See, this is
there is
not
a matter of agreement, my lord.
This is not a railway platform where you casually walk in.
No, my lord. This is a readable, my lord. It's a matter of agreement, my lord.
Let's treat it with that decorum and dignity it deserves.
Let me next week.
It's all right.
It's
all right. It's all right. It's all right. No problems. Right.
Supplementary list item 24.
Yes.
I am for the opposite party. The vacancy was there, my lord. By virtue of entry model, my lord, we have already fill up the post, my lord. I am for the bank, my lord. And there is nothing remaining in this.
All right. Counsel, the appellant says that due to subsequent developments, the appeal has been rendered infructuous. It is disposed of as such.
The appearance of Union of India may kindly.
All right. Is the respondent okay? None appears for the appellant dismissal on prosecution. All right.
Bikram Sena.
Item 25.
May I please, madam? I don't 23 my liberty may given my lord. Anything is surprise, my lord, because I don't.
You can always file an application if anything surprise. Yes.
Item number 25.
Item number 25. I pray to let him come next week, my lord.
What is the matter about?
The matter is, my lord.
I'm appealing for the respondent.
The matter is, my lord. It is under EPF and MPF. I'm not ill, my lord. That is the part. I'm ill for which I am mentioning, my lord. Come till next week.
So 196 days delay, sir. What's the explanation given for the delay?
The file was.
That will not be accepted, sir, any longer. After the Supreme Court judgments, these are not valid grounds. You just put down MCC number 266 of 2017. There's an extraordinary delay of 196 days in filing the appeal. The only reason given in the application is about the file being misplaced. These are not relevant grounds for condoning the delay. The explanation is not satisfactory. Consequently, the delay is not condoned. MC case number so and so is dismissed. Consequently, the writ appeal is dismissed. Yeah, all the connected cases wherever there is a delay, all of them are dismissed.
Item 26.
May I please? And this appeal is directed against the order passed by the Honorable Single Judge dated 27/6/2017, by virtue of which the dropped contempt proceeding has been reopened and direction has been issued to do something in that manner as has been indicated therein. The brief issue involved in this case, my lord, on the first occasion, the Honorable Single Judge in the original writ petition passed an order directing for disposal of the representation which will be submitted by the present respondent. Accordingly, respondent submitted his representation. But since that was not been considered within the time bound as has been directed, so the present respondent filed a contempt petition bearing 431/2013, and by the Annexure 6, page 53, your lordship will find on the basis of the undertaking that the order will be complied within a period of 2 months. So the contempt proceeding was dropped. Thereafter, one miscase was filed in that disposed of contempt petition, saying therein that in spite of that direction, the order has not been complied. But in the meantime, the compliance order has been made under Annexure 8 at page 58. Pursuant to the order of the Honorable Single Judge in the writ petition, the representation of the present respondent was considered, and this reason was so. Accordingly, the show cause affidavit was filed in the contempt proceeding. Which
how is a writ appeal maintainable against an order passed in a contempt case?
Well, to that effect, that the decision in case of Midnapur. But since your lordship might kindly see,
your order has been implemented now.
No, they have not. They have not denied that I am not entitled for the period salary, but they are saying that you are working under the management. That's why they have not released. They have approved my salary,
the period I have claimed. Your Lordship may kindly see Annexure 4. Annexure 4, Annexure, first Annexure 2, page 21. They have approved my salary, post, my lord, by order 21/12/94. Serial number 2, Akshay Kumar Pradhan. Yeah. So and so in favor of the following non-teaching staff of the BR High School.
Reading, sir?
My lord.
Annexure 2, is it?
Annexure 2, page 21.
Yes.
My post was approved by order dated 21/12/94. That is Akshay Kumar Pradhan, allowed in the scale of a 750 to 94. Thereafter, Annexure 3, my lord, that was my scale was also revised from 750 to 94, my lord, 940, my lord. And since, my lord, thereafter, I was earlier in the school that I was transferred by Annexure 4 to the present school where I retired from service. And your Lordship, Annexure 4, they have in the writ appeal, page 23, the following 4th grade so-and-so employees of BR High School who have opted for remaining under the direct payment code in the wake of withdrawal of JIA order dated 4/93 but were retained in the same school, alternative arrangement made are hereby transferred and posted to act as such in Tekerebo school as noted against each of their own pay, keeping in view the term and condition of their approved post. Nowhere they have denied their approval order is illegal. And without any assigning any reason, they have not paying, and the petition is aged over 70-year-olds now in the death condition, and they are saying that you are not entitled.
Madam, kindly see page
No, where
58.
they have
To comply with the order, even now you're not complying.
No, your page 58 is the compliance.
50.
Yes, madam. Annexure 8, page 58. That was done pursuant to the order of this honorable court in by the honorable single judge in the writ petition. The representation of the present respondent was considered, and this order has been passed. The petitioner has performed his duties for the period he claims.
Is paragraph 4, your Lordship, may kindly see. In the page 58, relevant paragraph is paragraph 4. That after delinking of BR High School welfare from granting it so and so, pursuant to GO number so and so, Government School and Mass Education Department, Odisha, in official number, the upon petitioner was approved with effect from 1/3/94 by the then Inspector School, Sambalpur Circle, Sambalpur, in the scale of a 750 to 940. Further, in order number 19/196, the pay of the petitioner was fixed at rupees 790 with effect from 1/3/94 with the date of next increment on 1/5/94 by the then Inspector Sambalpur Circle, Sambalpur. My lord, then, my lord, paragraph 7.
No, 5, please.
Yes, the petition on dated 7/197 submitted an undertaking that he will abide by the condition of service applicable to government. That I am not disputing that. The only I am which has not been paid. Then, my lord, paragraph 7, the petitioner has performed his duty for the period he claims to release arrear salary, that is from 1/3/94 to 7/12/97 under the management of BR High School. Even admittedly, I am doing working on the management. I don't dispute that. If I have received any salary from the management, since my post has been approved by the government with effect from 1/3/94, by deducting the salary, they are bound to pay me, lord, because they have fixed my salary and they have revised also, and they are not disputing that fact.
Paragraph 5 is clear that on the basis of
page 59, they have categorically stated, page 59.
97, the salary was being paid. And for the period of service which he had rendered under the management, the government is not liable to make payment of the.
You've approved his salary from an earlier date.
Yes.
No, 1/3/94. From 1/3/94, you've approved his salary.
Yes.
The post the post was approved on the basis of his undertaking.
No, but
paragraph 5 of this page 58.
He has not received any money from BR High School.
Yes.
Management.
BR High School
has not received any payment.
No, my lord, because that period was under the management. In the Anchalik Balika Vidyalaya, that during that course the salary has been paid. And moreover, the issue before a lordship.
No. See, just come to the para 2 in page 59.
Page 59, man.
Para 2.
The appointment of the petitioner was approved with effect from 1/3/1994, office order number such and such, after delinking BR High School Belpar from with effect from 1/11/1994.
So once you delink them from the granting aid, they're not going to pay his salary. How do you expect that BR High School management to pay him salary after 11194.
But he
You
was
already delinked them from the.
but he was only adjusted in the government taken over school in 1997.
No, what happens for the work he has done from 11194 to 71297? That is what he's asking. Somebody has to pay him.
The management is.
How can it pay, sir? Once you stop the grant in aid, they cannot pay.
And moreover, here the issue is something different. Issue is, my lord, pursuant to the order of the Honorable Single Judge, the representation of the petition present respondent was considered. My response to submission in view of that 1996 Supreme Court may not be in conformity, full conformity of the order of the.
So the man is 70 years old. Don't make him run around. You say again he has to start a fresh litigation if he's aggrieved by that order, correct?
Yes, my lord.
At 75 years old, he will now start a fresh litigation. He will file counter, rejoinder. Another 10 years, he's not going to be alive.
Then, my lord, may I suggest one thing? Your lordship may keep this particular question of law open.
All right.
Because this is a very vital issue with regard to reopening
over 75 years old
after being dropped.
And the claim is only for a period of 3 years, during which he performed his duties. That is 1st March 1994 to 7/12/1997. Full stop. The case of the appellant is that he was still working under the erstwhile management of BR High School, Belpahad, whereas the order itself, the order of the district dated 1st May 2017 itself, indicates that the grant in aid to the said school was stopped with effect from 1st November 1994. The respondent therefore could not be left high and dry as regards his claim for pay for the aforementioned period. Stop. In the circumstances, the court sees no reason why it should interfere with the impugned order of the single judge. Nevertheless, it is clarified that the said order will be treated as having been passed in the particular facts and circumstances of the case and will not create a precedent. The appeal is accordingly dismissed. The interim order is vacated.
Item 27.
And here one thing, by virtue of that impugned order, direction was passed for a personal appearance. Your lordship may dispense with that.
However, the requirement for personal appearance of the officer concerned is
dispensed with, subject to compliance.
Subject to compliance with the above directives. Right. The contempt case 431 of 2013 now be listed before the roster bench of the single judge.
That contempt was earlier dropped.
That will be decided because compliance of this honorable court is not satisfied.
This was the issue before your lordship that
whether honorable single judge will decide.
Contempt is dropped. Whether that can be reopened by virtue of an interlocutory application.
No. Sir, you got to stay that the contempt case 431 was listed for 17/7/2017.
Yes.
When it was stayed by this court. So we are asking for that to be listed now for direction.
That was dropped on 23 March 2014.
No, sir. Please come to the impugned order, page 69.
No, prior to that, yes, I have seen that.
Prior to that petition, we are now asking it to be listed now before this roster bench of the single judge.
But prior to that, your lordship.
So prior petition, we are not concerned.
No, not prior.
You have filed this appeal against this order.
Yes.
The order at page 69, sir.
Yes.
And this is not a disposed of matter. It was
that is the disposed of. I am trying to say page 53, your lordship can just have just 1 second, my lord. Page 53, Annex 6. That is the issue.
They've revived it, sir. They've revived the contempt because you did not comply with the earlier one.
But that is not permissible, my submission. That is not permissible. However, under the basis which your lordship passed the order, I am not on the way that concession because
let it be listed for directions on 19 December 2022. All right.
Supplementary list item 27.
No instruction, my lord.
Counsel for the appellant states he has no instructions. Dismissed.
Item number 28.
My lord, I am from the petitioner extremely sorry for appearing through my lord because of my personal inconvenience. Here, my lord, matter relating to trade certificate and batch of the matters are posted on 5th December for consideration.
All right, list on 5th December. All right.
Item 29.
May I please your lordship? My lord, I have filed this writ appeal challenging the Honorable
Judge dated 27/6/2017 by the Annexure 4, my lord. The fact of case is that, my lord, the present respondent number, the father of the respondent number 2211, my lord, filed a revision case under section 37(1) of OCHPFL Act after.
How is this writ appeal maintainable?
My lord, this is a writ application under section 226, my lord.
All right, tell us.
My lord, my humble submission before your lordships, the father of the respondent 2211 filed a revision case under section 37(1) of OCHPFL
This is a
Act.
remand order. After the remand, what is the status might have been disposed of?
No, there is
within 6 months from the
So
date.
was there a stay here?
still now that case is pending, my lord.
No, there is no stay.
No, there's no stay. It's only a remand order, sir. Let it be worked out.
My lord, my humble submission, my lord, my humble submission before your lordships, my lord, 37(1) application is not maintainable according to section 14 of OCHPFL Act, my lord.
Before the revisional authority.
No. Revisional, when the honorable single judge has decided that 37(1) application is maintainable.
Where has he decided? He simply remanded it. He's not decided at that point.
My lord, the commissioner remanded the matter, my lord. Against, I preferred a writ application. In the writ application, I preferred a 3 points, raised at 3 points, that the said revision case is not maintainable because that has been filed after 24 years publication of the ROR, my lord.
Maintainability is different from limitation.
Yes.
You're mixing up 2 points, sir. Limitation is different from maintainability.
My lord, as per my instruction, my lord, that case is still pending. Even if there is no stay.
All the points there, sir. It is stated that it is seen that by the impugned order dated 27 June 2017, all that the learned single judge has done is to remand the revision petition to the Additional Commissioner Settlement and Consolidation, Balashore, for a fresh disposal in accordance with law. Although there is no stay of the impugned order of the learned single judge, counsel for the appellant submits that the case on remand is still pending before the aforementioned authority. Paragraph. If that be so, it will be open to the appellant to urge all the pleas available to the appellant in accordance with law before such revisional authority, including the plea of limitation and maintainability. No further directions are called for the writ appeal poster.
Grateful, my lord.
Item note 30.
Nana.
My lordship, on behalf of Mr. Ramesh Agarwal, my lordship, from item number 30 to 33, they all are the connecting matters, of which the order dated 12/10/2022 was directed. May I serve the order, my lordship?
That trade certificate matter, lordship keep that matter on 5th of December.
The trade certificate matter.
Yes, my lordship.
So,
Much obliged.
Up to 33. Item note 34.
May I please, your lordship? Your lordship, the appellant here is challenging the order dated 25/7/2017 of the Honorable Single Judge, your lordship, wherein we are challenging that under regulation 2, this matter is related to regulation 2, your lordship. We are challenging that we are in the adverse position of the land since last 40 years, and that the current respondent has filed a application.
We have to obtain the instruct because this is a remand order within 2 weeks or 2 months. The Honorable Single Judge is directed to conduct the inquiry. What is the status, whether the inquiry has...
Because never come up even once, sir. So no stay, nothing.
Nothing.
No, your lordship.
Yeah, so it's a mere remand order. Why should
It's a
we
clearly
interfere?
remand order. The inquiry was respect to that they will form an opinion about the value of the land.
Of the learned single judge merely remanding the matter to the
ADM
Gajapati for a fresh inquiry, for a fresh decision in accordance with law. There has been no stay of the impugned order for over 5 years now.
Not ADM, your lordship, officer on special duty, LR Parlekhamundi.
Officer
Officer
on
on
officer on special duty From LR Parlek Mundi. All right. There's been no stay of the impugned order for over 5 years now. Assuming that the matter is still pending on remand before the aforementioned authority, it will be open to the appellant to urge all the pleas available to the appellant in accordance with law before such authority. The writ appeal is accordingly disposed of.
Item number 35.
Item number 35, may I please, Your Lordship? My lords, here I have preferred the present writ appeal against the order passed by Honorable Single Judge dated 18/7/2017 vide Annexure 1, my lords. My lords, here my grievance before your lordships is that, my lords, I had purchased a plot of land in the year 1984 from the grandfather of the present OPs 3 and 4, my lords. And my lords, I have been in peaceful possession of the land since. My lords, subsequently in 2005, my lords, an OSA case number 704/2004 was initiated against the Odisha SATIP regulations 1956. Regulation 2, my lords. My lords, thereafter, I preferred a writ petition before this honorable court vide WPC number 2693 in the year 2007, wherein the honorable court directed that this case was to be remanded and heard again by the opposite party 2, my lords. Yes. My lords, the opposite party 2 thereafter, mechanically without taking the grounds put forth by me, rejected the order and reversed the land under 3B1 of the said regulation vide his order dated 29/12/2007, which is at Annexure 2, your lordships. My lords, my grievance now here is, my lords, may kindly see 3B1 of the Odisha scheduled areas transfer of immovable property by scheduled tribe regulation 1956.
You have to take prior permission, sir. Such a small point. Did you take prior permission or not is only question.
My lords, actually,
only question. He has not taken the permission, so it is
the end of the matter.
It is a bird sale.
Very straightforward, sir.
My lords, may kindly consider that the sale was effectuated in the year 1954 and this regulation came into force in the year 1956.
Yes.
My lords, may kindly take a look at...
What's the date of the sale, you said?
My lords, 1954.
Where do you get that?
My lords, may kindly see Annexure 3, which is a civil suit filed by me for possession and title of the said land, my lords. At Annexure 3, page 32.
What's the date of that, sir?
My lords.
What's the date of this order?
Judgment.
My lords, the date of the order, Annexure 3, page 32, the date of the order is 7th May, passed by the learned Civil Judge, Senior Division, Jaipur.
So it's 2005.
By virtue of that decree, they claim to have...
My lords, we claim title and possession of the said land by this case.
So that only from this decree,
my lords,
you have to calculate then.
My lords.
Not 1954.
My lords, it is noted in the said order that we purchased the land back in 1954. My lords, I do not have the exact date, but the purchase was, and it is not disputed that we have been in possession of the said land since 1954.
Possession has nothing to do.
Neither here nor there, sir. Here being possession does not mean anything.
And my lords,
purchase can be only by a registered sale, not near the document.
My lords, may kindly appreciate one more thing. My lords, according to the ST, my lords, one moment. My lords, as per the Constitution Scheduled Tribes Order 1950, my lords, this case was instituted in the year 2005 against me before the learned sub-collector. My lords, 3(1)(b) of the said, my lords, section 3(1)(b) says that every person who, on the date of commencement of Odisha scheduled areas transfer of immovable property.
You are not recognized owner till you got the decree of the civil court in 2004, is it?
My lords.
Or 2005?
2005.
By which time regulation 2 of 56 was very much in place.
My lords.
So you can't take advantage of this retrospectivity and all of that.
My lords, but this is not applicable to the...
If you have a registered sale deed of 1954, you may have an arguable point. You might have a registered sale deed of that date.
My lords, may then kindly give me short time. I'll obtain instructions.
Not like that, sir. This is not for instruction.
if the sale deed
You would not have gone for a civil court decree for declaring title if you had a registered sale deed. Why would you do that? Even today, you do not know the date of purchase in 1954.
My lords.
This can't suddenly, the fact can't be manufactured between today's hearing and the adjourned date.
My lords, but the fact remains that as per this petition, this case was instituted against me under section 3B1. My lords, according to section 3B1, it is only applicable to lands which belong to a member of the scheduled tribe at any time during the period commencing on the 4th of October 1956 and ending on the date of commencement on the amended ration of 2000. And that application too shall be made within 2 years, my lords. My lords, neither was this land in possession of a
Mere
scheduled
possession
tribe.
is not ownership, sir. Let us be very clear. Mere possession is not ownership.
My lords, what I respectfully submit before your lordships is that I had purchased this land prior to
Nothing to show that. Even today, we're repeatedly asking you, what is that to show that?
Annexed karna?
Is there a registered sale
It
deed?
has not been annexed.
No.
There is no registered sale deed.
My lords, because at the time of purchase, we purchased the land for
whatever, even if it's 2 rupees,
my lords, of 90 rupees.
Some document.
And at that point of time, a sale deed was only registrable if the value exceeded 100 rupees.
So you have to have some document then. It can't just be your oral say so.
Well, but the fact remains that we have been in the peaceful possession of the property.
That is the only thing that is in your favor.
What has happened, my lords? They claim that the sale is of 54. That is a sale deed basing on an unregistered account because the consideration value is less than 100 rupees. Maybe a oral sale deed. So oral sale is also permissible if the value is. This have been set up for the purpose of getting over this rigors of this rule. That is usually.
My lords, how can that be when the regulation itself came in 1956 to 2 years prior, they thought that in order to bypass this regulation.
No. That is why in this suit, you set up a claim of title and got a decree.
Yeah, that's right.
Because you had no registered sale deed of 1954.
Correct. This writ appeal is directed against an order dated 18 July 2017 passed by the London Single Judge dismissing writ petition civil 1586 of 2008 filed appellant. Paragraph in the said writ petition, the appellant had challenged an order dated 29 December 2007, passed by the Sub-Collector Jaipur. Declining to recognize the title of the appellant over suit plot number 178, area AC 4.32, cent of Khata number 47 in village Banka Bija under Jaipur Tahsil, on the ground that before acquiring the said land, purchasing the said land, prior permission under section 3(1) of the regulation 2 of 1956 was not obtained. Paragraph. Although the appellant asserts that the suit land was purchased sometime in 1954, that is prior to the coming into force of regulation 2 of 1956, the appellant has never been able to make good that assertion. Stop. On the contrary, a civil suit number 27 of 2004 appears to have been filed before the Civil Judge Senior Division Jaipur, which came to be decreed on the 7th day of May 2005, recognizing the ownership of the appellant to suit land. Full stop. If indeed there had been a regular purchase through a registered sale deed or any other document evincing such purchase, there would have been no need for the appellant to go in for a civil court decree. Full stop. Consequently, as far as the appellant is concerned, with his recognition of his ownership of the land in question happening only in 2005, the question of non-applicability of Regulation 2 of 1956 does not arise. Paragraph. Consequently, the court is unable to find any error having been committed by either the sub-collector or by the learned single judge affirming such order of the collector. Full stop. There is no merit in the present writ appeal. It is dismissed as such.
I'm obliged.
Item 36.
36. My pleasure. The petitioners challenge the arbitrariness of the object parties. Can you have a glance? Annexure, by virtue of Annexure 1, the petitioner applied for the education grade 2 post. By virtue of Annexure 1 series, the qualifying mark is 33% to calling for a fiber test. But the present petitioner securing 50% marks, but they are not called for the fiber test. Can you have a glance? Page 34 at Annexure 4 series. I have obtained from RT Act 34. It is informed that the minimum qualifying mark for vivo test is 33% for all categories. For all categories. Then kindly turn to page.
That's what I...
Page 31, my lord. The petitioner number 1, secure 172. That is 49.142%. And petitioner number 2.
The impugned order was simply saying that you have to approach the OAT.
Exactly.
Now you single judge will set it aside, goes back.
The scope and power of the educational tribunal. That is not maintainable for the, because
anyway, the tribunal has got abolished, sir. Anyway, the single judge has to hear it.
So the party should not be remedialist.
That's right. You say the impugned order dismissed the writ petition civil 7556 of 2017 of the petitioner, of the appellant, on the ground that the appropriate forum was the State Administrative Tribunal, bracket SAT, full stop. While at that point in time, the SAT was still functioning, as of date, it has already abolished. Full stop. The appellant obviously cannot be without a remedy. Full stop. Since in any event, such matters are to be filed only before the single judge of this court. The court sets aside the impugned order dated 1st August 2017 and restores writ petition civil 7556 of 2017 to the file of the learned single judge. It will be listed before the roster bench of the learned single judge for directions on 12th December 2022. The appeal is disposed of in the above terms.
Item 37.
Item 37, Your Lordship. May I please, Your Lordship? Lordship, this writ appeal has been filed against the order dated 21st September 2017 against the judgment of the learned judge in writ petition 8649/2006, my lord. Lordship, while order dated 23rd February 2022, this honorable court was pleased to admit the writ appeal and further directed the interim order confirmed. My lord, in this matter, Mr. Pitambar Acharya has instruction to appear, but he is on accommodation today. So may I pray before Lordship for a adjournment?
No, you seem to be familiar with the facts, sir. Tell us what is wrong with the impugned order.
Lordship, I don't have power and Mr. Acharya has specific instruction, my lord. Any day as it pleases your Lordship.
Page 10 of the impugned order, the Honorable Single Judge has purportedly exercised power under Article 2, page 10, paragraph 20.
Yes.
Paragraph 10, page 27.
227. There's no appeal maintainable.
So
it appears that the impugned order of the learned
Lordship may fix a short date, my lord, any day, maybe tomorrow.
Against the 227 order, there is no appeal maintainable, sir.
Tomorrow, my lord.
No. There's no appeal maintainable against the 227 order. It is plain from the impugned
in the
order of the single
meantime,
judge
may I,
that he was
Lordship?
exercising the jurisdiction under Article 227 of the Constitution while entertaining writ petition civil 8649 of 2006 against an order passed by the Tahsildar Berhampur regarding order passed by Tahsildar Berhampur in terms of Rule 8 of the Orissa Certificate bracket for Scheduled Castes and Scheduled Tribes bracket Rules 1980. Paragraph against an order passed by the single judge under Article 227 of the Constitution. No writ appeal as such is maintainable. By virtue of the judgment of the full bench of this court put down that there's an earlier judgment. Consequently, the writ appeal is rejected on the ground of maintainability.
Lordship, may I pray?
The interim order, my lord, the lordship's leave, my
Interim
lord.
order is vacated.
Lordship, in the meantime, the petitioner has already retired with full satisfaction service, my lord. If it will be vacated, he will be prejudiced. May it be taken up tomorrow, my lord?
No. It's all right. Yes.
Item number 39. Sorry. Item 38.
On behalf of Mr. D.K. Dhar, my lord, I pray for adjournment.
No, sir. What is the delay? What's the matter about, sir? Tell us.
I have no power and I have not filed.
Then we'll dismiss for non-prosecution. Counsel for the appellant seeks an adjournment which the court is not prepared to grant. When asked to argue, he says he has no authorization to argue the matter. No lawyer authorized to argue is appearing for the appellant today. Dismiss for non-prosecution.
Item 39.
I am appearing for of this party. We'll go.
Yes.
Item 39.
39.
None appears. Dismissed.
Item number 40.
Memo is taken on record. Dismisses withdrawn.
Item 41.
41, the issue is whether collector has power to transfer the GRS. My lord already issues are decided by my lordship.
Already covered by 401 of 2017.
Let's get it out.
Item 41, 42, 43, 44.
And also 57, 58, 59 also.
And 61.
In view of the judgment of this court in Gagan Bihari Patra versus State of Orissa 2022 SEC Online, Orissa 2957. These appeals are dismissed. The appeals are dismissed, right? Yes.
My lord already decided this.
Right.
I have nothing to.
All of those matters. What are the up to 44 and
44.
41, 42, 43, 44, 57, 58, 59, 61.
Odd. Just put down all the numbers.
Item number 45.
My lord, 45, the appellant has challenged the order dated 2827 of Honorable Single Judge passed in WPC number 21269 of 2015 under Annexure 1, my lord. My lord, of the response number 1 is employee, is original employee, Lepoda Lamb. The appellant is the Sundargarh District Central Cooperative Bank. My lord, Annexure 2, page 24, is joining report of response number 1, my lord. He has joined in the Lefripoda Lab, which is a other cooperative, primary cooperative society, my lord.
So there is no stay of the impugned order. Have you implemented it or not?
No, not implemented, my lord.
Then what about the other side? They have not filed a contempt also.
No.
Then there's nobody interested, sir. If he files a contempt, you give you permission to revive this. In the last over 5 years, the appellant has come out, despite there being no stay of the impugned order, not implemented it. counsel, the appellant informs the court that the respondent who benefited by the impugned order has also not filed any contempt petition seeking its implementation. Full stop. Consequently, the court sees no reason why it should interfere. In the event that the respondent seeks to implement the impugned order of the single judge, it will be open to the appellant to revive the present appeal. It is disposed of as such.
Item number 46.
Minutes, item number 46, I am for the appellant. I am running with fever since yesterday.
All right,
Can I
counsel
pray-
for the appellant to be unwell. List on.
Any convenient date, minutes, suddenly I
17 January, sir.
oblige, minutes, oblige.
Item 47.
My lord, this appeal arises out of the order of Honorable Single Judge by order dated 1/11/2017, not awarding any compensation in electric bond case, my lord. The fact is like this: when a petitioner was going to the land, to his land, my lord, in the way he came in contact with the lead electric, which is hanging in very low height, my lord, and he sustained injury and remained as an indoor patient more than 1.5 months, my lord. And the electric department itself has filed stationary entry admitting the accident, my lord. But no compensation without any awarding interim compensation or full compensation has simply dismissed my notice, may be issued.
No, but that was some cases interim compensation. Actually, this has to be proved in a civil court, sir. This has to be proved in a civil court. The appeal is directed against the judgment dated 1st November 2017, passed with the single judge, rejecting the appellant's writ petition civil 20296 of 2009, in which a prayer had been for a direction to the respondents to award compensation to the appellant on account of injury sustained due to electric shock. Paragraph, the learned single judge has noted that the disputed questions of fact had to be established by proceedings in a civil court. Full stop. Unless negligence of the respondent was demonstrated, it would not be possible for the learned single judge to order compensation. Full stop. In these circumstances, the court finds no error having been committed by the learned single judge, which requires interference. The appeal is dismissed.
Supplementary item 48.
Are they permitted to file civil suit?
Yeah, it will be open to the appellant, seek appropriate remedies in a court law. Yes.
And then delay will be condoned, my lord.
No. We don't know about that, sir.
May I please, your lordship? Item 48, your lordship. It is similar to item number 35, your lordship. And wherein the civil suit was, bearing number is TS number 14 of 2000, wherein the landed civil court has decided the possession of the petition. Similar type case, regulation 2 of 1956, your lordship.
So it is dismissed in view of the judgment passed today in writ appeal number
469 of 2007.
No,
Yeah,
that is
sorry, 35, item number 35.
35 item, yes.
271 of 2017. The present appeal is dismissed.
Wherein the some plot number is you have mine.
No,
Plot number.
Second one is also same.
Item 49.
49 is also
same.
Delay to be continued.
Delay is condoned in both. Correct.
Item number 50.
Lordship, this is against the order of the Honorable Single Judge.
101 days delay, sir.
The facts constituting this appeal is that, Lordship.
It's 101 days delay.
Lordship. The reason is that, Lordship, the brief was entrusted by a local advocate. And after this order was passed, he was intimated about the result of the writ petition. In the meantime, that advocate had left practice, Lordship. And on 1/12/2017, I received a telephone call from the present appellant. And he inquired about the case, and I intimated him about the fact of the judgment in the writ application. Thereafter, he came and the writ appeal was filed. So it was, the judgment was not within the knowledge of the present. Lordship, the facts, may I place the facts, Lordship?
Yes.
The facts is that, Lordship, the
respondent number 3 was the financial advisor, the insurance advisor of State Bank of India, the local branch. He went to the village, made a meeting of the villagers and introduced to them the insurance policies. Accordingly, many villagers came to the bank, deposited amounts. And in the bank, after the amounts were deposited, he had issued receipt. In some cases, policy bonds were also issued. And later on, the villagers came on inquiry that no policy has been opened in any case. And thereafter, the SBI filed an FIR against the respondent number 3, alleging therein that he had collected the policy amounts from the villagers and had misappropriated the amount. And accordingly, the FIR, the case was charge sheeted against the respondent number 3 and he is facing trial. Now the claim of the petitioner was made before the permanent Lok Adalat, and in the permanent Lok Adalat, it was allowed, Lordship, the award was passed, directing the respondent, making the respondent number 1 and the respondent number 2 jointly liable for the claim of the present appellant and others. And thereafter, challenging the award of the permanent Lok Adalat, the writ application was filed. And in the writ application, the bank took the plea that it was not permitted under the policy to make cash deposit. And as cash deposit were made by the parties, so the bank is not liable. And our stand is that, Lordship, the relationship of master and continued between the respondent number 3 and the respondent number 1. And accordingly, the respondent number 1, even if the action of the respondent number 3 was illegal, the respondent number 1 is liable to indemnify the actions of the respondent number 1.
No, but the proposal form clearly says it can't be in cash.
These are all rustic villagers, Lordship.
Whatever it is, as far as making the insurance company liable, if there's a bar on collecting cash, instead of issuing a policy after cash is collected, does not arise, sir. These clauses in the insurance forms are very strictly to be interpreted.
Lordship, may I place one decision of the Punjab and Haryana High Court in the full bench? I beg Lordship's pardon, this is only one copy.
We are used to that now, sir. We are used to that. Orissa High Court judges do not have a right to ask for copies of judgments. Yes. Which paragraph are you relying on? This is nothing to do with cash premium and all, sir.
No, not with cash premium, about the vicarious liability.
That is different, sir. That's a different issue.
Master and servant.
That is a different issue. You say the challenge in the present writ appeal is to an order judgment dated 25th July 2017, passed by a single judge, allowing writ petition civil. (2734) of 2013, filed by the respondent SBI Life Insurance Company Limited. Challenging an award dated 10 January 2013, passed by the Permanent Lok Adalat (PUS) Kionjar in PLA case number 20 of 2012. Paragraph. The short question before the single judge was whether the insurance company could be made liable to release policy bonds with the writ petitioner having deposited the premium amount by way of cash. Full stop. It appears that they were compelled to do so. They were persuaded to do so on account of single quotes, the approach made by Damayanti Mahanta, the insurance advisor, and Asit Kumar Swain, the unit manager of SBI Life Insurance Company. Unquote. The learned single judge found that there was a clear bar to cash being accepted for the premium amount. We'll stop. The clauses 8 and 9 of the proposal form left no manner of doubt that the mode of deposit is only by way of check or demand draft favoring the company. Full stop. Counsel for the full stop. Accordingly, the prayer of the order of the Permanent Lok Adalat (PSU) directing the company to issue the policy bonds was set aside by the learned single judge. Paragraph. Counsel of the appellant relied on the decision Kirti Singh versus Bindaram. AIR 1987, Punjab 56, where the settled principle of vicarious liability of the insurance company was reaffirmed, and it was held that if the driver is acting in the course of his employment, then the owner would be liable, even though he acted against the express instructions of the owner. We'll stop. The facts here are completely different. So the question here is regarding the obligation of the insurance company to issue a policy bond, notwithstanding that the express condition that the premium amount had to be deposited by way of check when they have to. Full stop. Consequently, the decision is of no assistance. The above decision is of no assistance to the appellant. Paragraph. Having heard learned counsel for the appellant and having perused the impugned order of the learned single judge, as well as the documents and record, the court is not satisfied that any ground has been made out for interference with the impugned order of the single judge. The court accordingly finds no merit in the present appeal. It is dismissed as such. Same is 51 and 52. Yeah. For the reasons stated in the order dated today's date, in writ appeal 478 of 2017, the present appeals are also dismissed.
Item 53.
May I please, Your Lordship? I mean, VC matter. Here, the appellant has challenged the order passed by the Honorable Single Judge, my Lord, upholding the proposition held by the ADM that the selection committee has no power to scrutinize the document, the genuineness of the document. My Lord, the Lordship may turn to page 23, my Lord. This is selection made with regard to Anganwadi worker, my Lord. Serial number 1, my Lord, but here he has secured admittedly more marks than that of the petitioner, my Lord. I am qualified than that of petitioner opposite party, my Lord. But Your Lordship may see, he has produced Madhyama certificate. I challenge that certificate on 2 grounds, my Lord. Your Lordship may see, my lord, page number 23, my lord, your Lordship, 21 and 22 are both mark sheet and certificate, my lord. The roll number are different in mark sheet and certificate.
The service is not complete, sir.
My lord,
Notice issued was returned with the report insufficient address, and the defect is not even removed. And how much delay?
21.
20 days.
That's all right, but you have not furnished the correct address.
That was the address given in the writ application, my lord.
What to do, sir? Unless the served.
I'll file the correct address, my lord. Within 7 days, I'll file correct address, my lord.
The notice to respond before has been returned with the remarks insufficient address. The appellant undertakes to ascertain and file in the registry within 4 weeks the correct present address of respond before. Thereafter, fresh notice be issued. Returnable on 24th January.
Item 54.
54, may I please your lordship. The present appeal arising out of order dated judgment dated 3/11/2017 passed by the Honorable Single Judge in WPC number 438 of 2015, directing the allotment of the sub-rooms in favor of the respondent number 2 to 17, ignoring the appellant's
Here
claim
actually,
for
I'm for the
allotment of the
respondent one.
sub-rooms.
I'm sorry to, I'm for the respondent one. 4 other appeals were filed against the same judgment. They were disposed of in 2019. And they were already been, the order has also been implemented.
Oh, I see.
Well, that is altogether different aspects, my lord.
Same common judgment, sir.
Present appellants are aspirants and depositors. No way similar footing with that of the
It's a common judgment.
It's
a common judgment, sir.
Here is the judgment in that regard. The appellants were depositors, my lord. There are 3 sets of beneficiaries. One is depositors, second is original LOT, and third is the street vendors. And the judgments were in favor of the street vendors. We are different footings here, my lord.
Relief granted, just see what, they're not dismissed it. They've said they should consider the case of the appellants in terms of the actions of the single judge within a period of 4 months.
And that has been implemented since 2019.
No, but these people have the same benefit.
My lord, single.
Just see the order direction issued by the division bench.
Order dated 3/11, my lord. Impugn order.
That has been implemented. There were a total number of 24 shop rooms. Through a lottery system, every shop room has been allotted. Now there is no vacant shop room. So, all those shop rooms have been allotted in compliance of this judgment.
No, my lord, in the year 2002, my lord, there are advertisement for 76 shop rooms, construction of. Out of 70 to be constructed, but they have constructed only 24 shop rooms. And they have allotted 16 numbers of shop rooms to the original LOT. Thereafter, my lord, pursuant to the order dated 3/11/2017, they have allotted 8 numbers of rooms, and rest they have not constructed, but they have collected money from the appellants since 2002, my lord.
But that's the same case with all these people also.
Yes.
These appellants also had the same case.
Yes. That's why we were directed to consider the case.
We have not noticed, my lord. We have not given opportunity in that case. We have not met parties. My lord, they have filed a separate appeal and take an order from the honorable court, my lord.
Here, actually, what has happened, there were two category of allottees. One was who were already in position earlier, and one was the present here, the appellant. So who were street vendors, and we were directed to consider their case. So total the number of street vendors was 16. And after allotment, there were only 8 shop rooms which were vacant. So there were actually, after this subsequent writ petitions was filed, in a subsequent writ petition, a direction was given that since there are 16 persons and only 16 persons and only 8 shop rooms, allotment will be given through lottery basis. After this, another writ petition was filed, and in fact, the same appellant was also had filed another writ petition.
That consideration, my lord, consideration for the case of the respondent number 2 has been challenged, my lord, because in spite of the single judge satisfied and quash the order under Annexure 4, my lord, the landlord single judge has given favorable order in favor of the respondent number 2 to 17, my lord.
Well,
have a glanced on page
your lordship's permit,
32, my lord.
if your lordship's permit, my lords, I'm not in this matter, but my lords, I also appeared for 6 of these persons who have been affected. They were getting those writ appeals, my lords.
Correct.
And even though directions have been made repeatedly by this honorable court to accommodate these persons, nothing is being done. And they were given allotments in an area which is about 2 kilometers away from the city, where, my lords, there would be no option. There is no possibility of carrying on any trade. And, my lords, there was initially a plan to construct 72 shop rooms in 3 floors. They stopped constructions after constructing 4. Even though they have the money with them, they are not proceeding with the construction.
Why were you aggrieved by the single judge's order?
Well, the single judge's order, in fact, there were 2 categories of persons. The single judge held that the persons who were in the shop rooms would be getting a precedence over us, who were also street vendors who were at the outset at the same time. So against that, we had come in a writ appeal. This writ appeal confirmed the order of the learned single judge, but said that yes, our and we would be made an allotment within a period of 4 months. That did not happen, for which we again filed another writ petition, which is sub judice, which is again before another bench of this honorable court that is being heard. And your lordships on one occasion had seen the video, because we were arguing that there is a
vacant in the basement, there is space and all that.
There is 5,000 square feet of vacant area, which is meant as parking for the shop owners of the first and second floor.
Right.
We wanted space there. Now that is all being done.
What is your grievance?
My grievance is only 3 points, my lord. My lord, in the impugned judgment, my lord, have a glance of page number 32, my lord.
Yes.
32. Yes. It is been categorically indicated in that allottees who were doing their business in the old market complex, who have filed other writ petitions, being WPC number 1351 of 2015 and WPC 4438 of 2015. That is not correct, my lord. My lord, have a glance annexure at page, my lord, 27, my lord. We are not original allottees.
So grievance, we are not even understand what are the grievance.
My lord, the appellant has a challenge in writ petitions. The provisional order under Annexure 4, my lord, 4 has been challenged. That has been quashed by the learned single judge. My lord,
I am not able to understand anything you are saying, sir. You applied for a shop, correct?
Shop, my lord. We are press in aspirants, my lord.
All right.
Pursuant to the advertisement.
Right.
Accordingly, we deposited.
All right.
And waited for depositing further amount.
All right.
Thereafter, they inspired the opposite party number 1 and 18 issued by provisional order in favor of the respondent number 2 to 17.
All right.
Challenging that order, we have filed a writ petition. That writ petition, the honorable single judge satisfied and accordingly quash the provisional order. Order under Annexure 5, my lord, at page, my lord.
I agree.
Though the honorable single judge quashed, and satisfied in favor of the appellants. But in the operating portion, for the land single judge, have the Koraput municipality is directed to consider the case of the footpath vendors, means respondents.
Only consider the case, sir.
I don't objection, my lord. They may allot, but we should allot. We are the also aspirants. We have deposited money. They are not the depositors. The street footpath vendor.
50%, but already
allotted, and for the
in the meantime,
another writ petition is already pending.
And
the same appellant has filed. Same appellant has also
the order
filed.
is already worked out, sir. Already it's been worked out.
And my lord, they have proposed for 76 shop rooms. Only constructing them, they will snatch away our monies. Lot of money they have collected from us.
But how do you leave people like
may I suggest you?
How did you consider their case also when you went to?
Yes.
Their case was
we have not.
Their case was considered. Actually, but
no. The case of these appellants was considered.
Yes. For there were 16 people. In fact, these appellant have filed subsequent writ petitions also.
Oh, I see.
Have been by this honorable court.
Oh, I see. So these are 6 appellants here. Their cases already
already considered, and there was a direction to proceed by lottery basis by this honorable court in under writ petition. After this, there have been many subsequent writ petitions filed by same appellants.
Oh, I see. It appears that against the same common impugned judgment, writ appeals 429, 424, 28, 29, 432, and 487 of 2017 were filed, which were disposed of by the division bench by a common order dated 22nd February 2019, affirming the order of the learned single judge, but issuing a direction to the respondent Koraput municipality to consider the case of the appellants in terms of the direction issued by the learned single judge within a period of 4 months from that date. Paragraph. Counsel for the Koraput municipality informs the court that the present 6 appellants' cases have also been considered, and there have been subsequent writ petitions filed by the same appellants for agreed by the non-allotment of shops. Stop. In that view of the matter, the impugned judgment of the learned single judge appears to have already been worked out. Consequently, it calls for no interference. Writ appeal is disposed of. Right.
Both the cases.
Both the cases.
Item number 55.
Next item not similar, my lord. Next item 483 of 2017. Their case has not been considered in this case. Though the earlier 6 numbers of their case may be considered, but in this case, 13 numbers of appellants.
No, 14 must be. 14 petitioners at least, writ petitioners. Same order. It's the same order. For the reasons stated there in the appeal is disposed. Right.
Item 55.
Limitation steps not taken. What's it is? Tell us what the matter is about.
My lord, challenging the order dated 23/10 of 2017, my lord, passed by the Honorable Judge of this Honorable Court is WPC number 1150 of 2017, my lord. The writ petition WPC number 1150 of 2017, challenging the resolution dated 26/12 of 16 issued by the respondents on the ground of arbitrariness and also seeking a direct to the state government authority to fix the average
This
limit
is biased. It's a common order in several hundreds of writ petitions. What has happened in the appeal filed by others too?
Yes, so one of those cases, item 40, today's case, that is being, I think, disposed of and been dismissed. The matter relating to the policy decision of the government.
That's right. There's no question of relaxation being granted. How can relaxation be granted by the court? You see, the learned single judge is dealing with writ petitions, including that filed with the present petitioners, seeking a direction to the state to relax the age, relax the maximum age for appearance for engagement as Sikya Sahayaks. Full stop. Although the age had been restricted, maximum age had been restricted by the government to 32 years, the direction sought was to fix the upper age limit to 42 years. So this was clearly a policy matter in which the court could not have interfered. And accordingly, the prayer has been rightly rejected by the learned single judge. Stop. No case is made out for interference. The appeal is dismissed.
Item 57.
None appeal is dismissed.
57 that GRS made.
Item 57.
57, none is appearing, sir. Dismissed.
Item number 60.
None appeal is dismissed.
Item number 62.
Item number 62, the Honorable Single Judge order, page 59. That order was passed on the date of first date. But in fact, the decision which has been relied upon by the Honorable Single Judge, I was just checking out
21 days, sir. 221 days delay, not properly explained. Accordingly, MC number 836 of 2017 is dismissed. The appeal is dismissed.
Supplementary list item 63.
May please, Your Lordship. One of the petitioner is an advocate of Keonjhar Bar Association, has filed this litigation, my Lord. Not challenging the notification under Annexure 1, and Your Lordship may found the copy application to provide ROR, record of rights, has been rejected by the opposite parties. In view
your representation, you see the petitioner's representation dated 17 September 2021 shall be examined by the collector, Keonjhar, and after and give him a hearing, a detailed order shall be passed thereon not later than 2023. And the order may be available to the petitioner within a week thereafter. The court clarifies it has not expressed any view in the matter.
Item number 64. Please, Your Lordship. See, matter related to Shishu Bhavan on 19/7/2022. I may read the.
We'll take up some other day, sir. Today there's a reference at 2 o'clock. Reference today at 2 o'clock. List on, give it. January.
May I pray, my Lord, a short date kindly fix, my Lordship's kind attention on the report submitted by the Advocates Committee. They have not given any reply. That is my submission, my Lord.
Let's see. All right.
Item 65.
65, my Lord, taken up any other day because after removal of defects.
Defects be removed within a week, list thereafter.
Item 66.
Same.
Item 66.
Item 67.
My Lord, 66, my Lord, I am.
Yeah.
Yes, my Lord.
67 also.
67.
I am.
Item 68.
My Lord, I am giving the 68 months. No delay, my Lord.
Same order. Right. All right.
Item 69.
Memo is taken on record. This post has withdrawn. Yeah, this post was withdrawn.
Item number 70.
70, my Lord, past day disposal, my Lord, page 68. Past day disposal.
Right.
In the event, my Lord,
but you not made a copy of the certified copy, so remove the defects.
Page 68, my Lord, is there from your Lord. Download, my Lord, the copy from the page 68. And I was opposite part number 4, my lord.
Say notice returnable. 2nd January. The impugned order shall remain stayed till.
Item 71.
71, my lord, I pray it to be taken with 82 because the question of maintainability is there regarding, and 82, my learned senior Mr. Mukherjee will address on the same self-issue of maintainability. This is an application where order of election tribunal has been challenged.
I know today there was a mention for that also.
Yes, 82.
Or
Is it other matter?
Item number 72.
72, maybe taken up in any other day.
In item number 72, my lord, I have already appeared on behalf of the appellant initially, my lord. Now, my lord, it shows from the noting, my lord, he has filed a prisoner petition to conduct the other counsel. But 4 days back, my lord, he contacted me over phone to ascertain his regarding his case, my lord. Let he be the appellant be informed. So, which counsel will conduct this case, my lord?
Yes, my lord.
He may be noticed, my lord.
What is your name, sir?
My lord, he has sent me the Bhagalat Nama along with and also file.
You are Mr. Bhuya?
Yes, my lord.
At the request of Mr. Lalit Bhuya, who says he now appears for the appellate. How long has he been in jail, sir?
More than 2 years, my lord.
Why are you seeking adjournment like this?
No, my lord, I don't want adjournment. It's short adjournment. Next week, I need it, my lord.
So there's a difference between a short adjournment and adjournment. The man is in 12 years in jail.
No, yes, sir.
You have no problem seeking adjournment.
Yes,
Let's start. November 21st.
Item 73.
Item 73, my lord. On behalf of Mr. Nath, kindly taken up 1 week after, my lord.
No, is that fresh matter or what? Admit the LCR be requisition, paper books be prepared within 8 weeks. Defects be removed in the meanwhile. No, it's already been admitted. Yeah.
My lord.
It's already been admitted.
Admitted.
LCR has been received.
Copy of this year also.
Received. All right. Say the fine amount is waived. That 1087 is disposed of. 1086 not pressed at this stage.
Item 74.
In the main criminal appeal, you say paper books be prepared within 8 weeks. Thereafter, the petition appeal be included in the list of regular hearing matters.
74, your lordship's judgment has been confirmed. I'm forwarding that. Your lordship's.
All right. Yes.
74, 75, and 77.
All right. So what's the order that we have? Yes. So we dispose of those writ petitions in terms of
74 to 77.
All right. You see, these writ petitions are disposed of in terms of the order dated 18th April 2022 of this court in writ petition civil 26692 of 2011. So it may be noted here that the Supreme Court has dismissed the specially petitions bracket civil bracket diary numbers 22626 of 22 filed against the said judgment on 10th October 2022. Right.
I am appearing for OP number 2, my lord.
All right.
All 4 cases.
Item 76.
Same.
Same. Up to 77.
Up to 77.
Item number 78.
78. All
And for the respondent, my lord.
And all the proceedings are complete. Some time is required. My lord say it is today's reference. So I will consume. I will take anything more.
All right. Whom are you for, sir?
I am for the petition appellant.
Appellate at the request of counsel the appellate.
My lord, a very short date. Maybe tomorrow any as possible.
29th November. 29th November, sir. Right.
Item 79.
9th November.
29th November.
May I please?
For a long time, my lord.
Can't do anything, sir. We are working very hard, sir. I don't know whether you realize that. We are not whiling away our time, no?
Yes.
That's okay. That's all right, sir. That's all right. Yes.
May I please, Your Lordship? Your Lordship, in item 79, I'm for the petitioner, Your Lordship, after your last order dated 5/7/2023, there are some subsequent developments in the matter which I need to bring it into record by additional affidavit, Your Lordship.
All right.
May I
Counsel,
can
when the
develop?
petitioner seeks to file an additional affidavit within 4 weeks, he is permitted to do so. List on December.
Obliged, Your Lordship.
Item 80.
Copy may be, sir.
Yeah, obviously, sir. Right.
May it please, my lord. That challenge has been made to the order of the learned single judge, my lord, by the annexure 1, in which, in a disciplinary proceeding,
we'll have it on some other days.
Yes,
there's
my
a
lord.
reference list on 13 December.
Right. Item number 81.
81 is FCRA matter. Supreme Court has 25th of 11. This all has been fixed up by the Supreme Court.
I know. So he mentioned this morning, Mr. Sen, but he had not informed you in advance. He says there are 2 other grounds of challenge which have not been dealt with by the Supreme Court.
Yeah, then have to examine, my lord.
You say it is pointed out by Mr. P.C. Sen and senior counsel appearing for the petitioner that although the Supreme Court of India has delivered its judgment in, what's the judgment date, sir?
There is a
Supreme Court judgment dates.
There is dated 7/2/2022
7/2/2022
and 27/9/2022.
So give us one date, sir. Supreme Court judgment must be only one date.
One date in interim 27/9/2022.
27/9/2022. He would still like to urge certain grounds of challenge to the act which have not been considered in the said judgment. At his request list on 15th November.
Item 82. 82.
The election tribunal allowed an application for amendment.
Actually, there was a mention made this morning. Was it connected to this, that Mr. K.K. Mishra, is it? What is his name? No. Physically, there was a Mr. Mishra who submitted. Some election matter, he said. What is that petition number?
1318 of 2022.
Something, I think it's similar to this. Yes, sir.
Lord, here my
We'll have to have it on some other day, sir, because 2 o'clock your colleagues have asked for a reference. This and that.
71.
71. List on. Which is the date fixed? The
date next.
My lord, for the election tribunal to proceed, my lord. Today, in fact, in 71, today's date. And 82, my lord, it has been fixed to 26th, probably, my lord. So
we'll have it on. We're having some other matters on 20th. Day after. We'll have this day after.
20th, my lord.
20th. Interim order to continue.
There is no interim order.
So 20th. That's what. 20th. Right.
Item 83.
83, I am appearing for OP number 5. I will file counter for each time to.
All right. At the request of OP number 5, who wants to. OP number 5, counsel appearing for OP number 5.
Yes, Lord.
Seeks and is granted 4 weeks to file a reply. Rejoined before the next date. 11 January.
Item number 84.
For Lordship, last order, my lord, directed to file the affidavit by the government.
84, my lord, I need some time to file the affidavits.
So already 2012 matter, sir.
My lord, give me
IANM 33. Why is this criminal appeal? What's something wrong? You see the previous order. Something wrong. Previous order, the caption be recorded, corrected. Is IE 133 is correct? Criminal case. At the request of council, government learned additional standing counsel for the government, who needs some more time to file the affidavit. List on. January 2023.
Item number 85.
85, my lord, it is a PIL for facilities of digging water to the villagers. My lord, next week it will come. Regarding supply of drinking water, they have already making a barricade and not allowing to for the cultivation. That will take some time. My lord. So that's why.
What's the previous order?
And
never listed, sir. How come these matters are not listed at all? Last time this matter was listed was when?
No, we are already filed rejoinder. Last time I filed rejoinder.
17th of August it was listed.
We filed rejoinder.
You are listed on 17th August, right?
That's right.
Where is that order? It's not.
We have filed that rejoinder.
Not scanned. This way, this is not scanned. See list on 1st December.
Item 86.
My lord, I'm for the petitioner. My lord, in item 86, it was directed to file counter affidavit by opposite party number 2, that is my lord, but not yet filed.
The reply of the state government be filed as a last option within 4 weeks. For the next day. 7th February.
Item 87.
This matter, my lord, the pleadings are over.
Correct. Pleadings are complete. List of final hearing on 9th.
Interim order to continue.
Against us. I am appealing for the state special engagement. Can we have it?
Convenient date.
We're having so many references, sir.
My lord, say. Could we have it on the
Authorities are very clear for the bar. So bar should not say both things. Please hold all references the day I ask, and please give us all early dates for all matters. This is a problem for the judges.
No, I was only suggesting praying for the end of this month last week. Any date convenient to your lordships last.
We'll all go to next year, sir.
My lords?
They have to go to next year.
The entire acquisition has been held up, my lord. The entire acquisition process has been stayed.
Can it be sometimes in first week of December? Man?
The entire acquisition process has been stayed.
November or first week of December?
Okay, 5th December.
Okay. Interim order to continue.
Interim order to continue.
Pastor matter item number 6.
Item 6, my lord. If read, my lord, Mr. Patnaik will argue in this matter. His heel, my lord, is went to Nimans for health checkup. My lord, only 1 week time.
Or it counts for the appellant state to be unwell. How is it maintainable, sir? Award of a laid over court.
Because, my lord, I was not, file is not with me. The telephonic instruction, that's why.
30th November, 30 November.
For hearing item number 88. For hearing item number 88.
In my house, some
88.
Sorry.
Which item, sir? 88?
6. Item 6.
It's all right. We're anywhere joining.
For hearing item 88.
Your Lordship, item 88, Your Lordship, Mr. Knight is on his legs, Your Lordship.
Tomorrow, we'll take it up tomorrow.
Your Lordship.
1996 appeal.
Yes, Your Lordship.
All right, tomorrow.
Item number 89.
Item number 89, my lord.
I'm prepared at the outset.
So then tomorrow we'll have it.
Yes.
If you're ready, we'll have it tomorrow.
Yes, ma'am.
All right.
I apologize, my lord. On the last occasion, actually, the petitioner was in custody for more than 15 years. I had to take an adjournment as the paperwork was not with me.
All right. Tomorrow.
I sincerely.
All right.
Item number 90.
It will come tomorrow, my lord?
Yes.
Oblige.
Item number 90.
Tomorrow.
This again tomorrow. Yeah.
Item number 91.
Item 91, your lordship. Bharti Das prefer next week.
24th November.
Item 92.
My lord, item 92, I pray for 4 time, my lord.
All right. 15th December.
5th December, my lord.
15th December.
Oh, like.